Yeah, yeah. Oh, we need to share. Okay, thank you. That's a cool thing.
This is the state of Wisconsin versus Franklin Dieters, 25 CF 2887. Can I have appearances, please?
State appears by ADA Lillian Nelson.
Attorney Derek Brown making a special appearance on Franklin Dieters. Franklin Dieters appears in person in custody. Have received a copy of the criminal complaint, waive its formal reading, stand mute as to the count 2, the misdemeanor charge.
Great. Mr. Dieters, we have an address for you on Blackbird Lane. Is that still a good spot for you to receive your mail?
Yes, it is.
All right. Well, is there an apartment number with that at all? Okay, we'll keep that address in our system then. You have the right to have an attorney represent you in a case like this. Looks like you have somebody. I find probable cause in the complaint. What are the state's recommendations?
State is requesting a signature bond, no contact with TYS, and a ban from Sun Prairie. My understanding is that Mr. Dieters lives in Madison and has no reason to be in Sun Prairie.
Okay, so the entire city.
Yes.
Okay. Any objection?
Your Honor, yes, I would not object to the no contact. I would object to a ban from an entire regional location. I think a ban from the blocks in which the victim allegedly lives is more than sufficient to protect her and protect the community. While Mr. Dieters does not live in Sun Prairie, it's my understanding he has doctor appointments that occur there. He also has friends and other people that he visits at that location. It is a bit unreasonable to put such a broad limitation upon someone's movements. It's pretty well defined in the statute that bond conditions are supposed to be specifically tailored to the alleged conduct. Here, there are no violations that are alleged to that he had in-person contact with this individual. It appears that what's being alleged is that 7 letters were sent to this individual in defiance of a injunction restraining order case. And it doesn't really seem to fit that because he sent her letters that he should be banned from Sun Prairie. Even if he's banned from Sun Prairie, he can continue to send her letters. So it doesn't really do anything to curtail the alleged of conduct. I just think it's overly broad and not necessary.
All right, response from the state?
Yes, I would just note that the victim is requesting the ban from Sun Prairie. However, if the court is inclined to just order an address ban, a more specific ban, I'd ask for a ban from the 1500 block of St. Albert the Great Drive in Sun Prairie, and also a ban from anywhere where the victim may be temporarily residing. So if he sees her anywhere in a public place, not to be in that area.
All right. So I pulled up a map of that particular part of Sun Prairie. It looks like, I think an area around that 1500 block could be the confines of the ban area. So what I'll do is I'll order a signature bond, and I'll order Mr. Dieters, you're banned from an area bordered on the north by Chadsworth Drive, bordered on the west by Broadway Drive, bordered on the south by Stephen Street, and bordered on the east by Allison Street, ALLISON, and Terra Drive. So it looks kind of like a square. That east border is a little wavy, but that'll be the area ban, all right? Do you understand what that means, sir?
Yeah.
Okay.
It
That
sounds like this previous map that we had before.
it might be, but this will be a little more specific than the entirety of Sun Prairie, but a little more broad than a specific address. Okay, so bordered on the north by Chadsworth Drive. That's CHADSWORTH. Bordered on the west by Broadway Drive. Ordered on the south by Stephen Street. Yep. And singular. And on the east by Allison Street and Terra Drive. That ban is also a no contact ban, so you can't send letters or anything to anybody in that area, all right?
Oh, you mean somebody and.
You can't send a letter with somebody's address if it falls within that area.
I can't think of anybody about to send it to anyway.
Very good, then it should be very easy to follow. I will also order that you have no contact with TYS. No contact means in person, by telephone, by mail, through a third party. No contact means no contact, all right? Do you understand it?
I assume that stands for.
I don't know whose name that is, but you can consult with your, right, you can consult with your attorney about who that person is, all right? I will enter a not guilty plea as to count 2. In regards to the time limits for the preliminary hearing on count 1, will the time limits be kept or waived?
Yeah, we would waive the time limits. I would also note that there's a competency hearing that is currently scheduled for January 27th in case 25CF1061. I think it'd be probably most appropriate to have this track with that, as I would raise competency on this case as well.
Right, any objection for proceeding that way by the state?
No objection.
Okay, then we'll get this set with that hearing, so you won't have to make a bunch of trips to court, hopefully. And with that, we are adjourned. Thank you, sir. Yep. Allison Street. Correct.
All right.
And if you want, I can draft some language. Cause it's. Nope.
So that might be in the area down to the skin under something that over on the north of Chatsworth Drive.
No, ordered on the north by Chatsworth Drive. Yep.
By.
Yep.
South by Stephen Street and east by Allison Street and Fair Drive.
Right.
My first.
I'm sorry, I didn't hear, you want it? Yes, please. Yep. I think that should be clear. Yep. Well, they do, but you can set up for status with the competency in the branch.
Yeah, I have all that. My issue is I don't.
Yeah, but you're gonna move, I'm reading the complaint. Yep. I don't have that many Spanish speaking the paralegals type these up by hand. We don't like dictate them.
No, I mean.
Someone has to like write every
program for
complaint.
all different languages. Like,
I mean, if there's like an easy translation program that worked well to run it through, that would make sense, but I think for actual copies that need to be filed with the court, it have to be done by like a certified translator.
yeah,
We don't have the resources of people, we don't even have enough attorneys to staff our offices. Like,
I'm
we're
just
not gonna
saying,
have
so
people
that
to do that.
Can understand it.
I agree with you in theory that that should be happening. I just don't think logistically, unfortunately, it's possible at this point.
Some counties.
That's just their rights. To know what they're charged with. It's just a thing. It's not minor. It's important for them to know and be able to read it when they get home. That's not Spanish.
Yeah.
Anyway,
Yeah.
they should know. what they're charged with.
One thing that I found to be useful is if I encounter a different language, is a Google app called Translate, and you can use your phone and it'll read the words and translate it on your screen, which is really nice. It's not an endorsement. I'm just sitting sure. I think I unmuted. Yep. Right,
Napoleon Suarez LLANOS.
and do you say your client's first name Napoleon, or is it something else? 'Cause
Are you
they-
asking me?
Yes,
Because
I-
I've met him?
I.
It's the Napoleon.
We don't know. We've not met him.
Napoleon.
And I'm pretty sure this is misspelled, the name, in first name on the complaint.
Okay,
Should we ask him?
Yeah. Hola, buenas tardes. Bueno, la primera pregunta, si está bien escrito, está bien. Napoleón o es Napoleón.
¿Cómo se escribe su nombre?
Leo. Así que se debe cambiar la L y la E, ¿verdad? Yeah, you have to switch the L and the E. First one.
Okay, so.
Buenas tardes. Sí. ¿Qué se llama Kathy John? Usted es Napoleón Suárez Llanos. Yes. Usted puede leer y escribir. No. I'm speaking in Spanish. So I'm going to speak as I speak.
Leer sí, pero no escribir no tanto.
Está correcta esta dirección aquí.
Okay.
very good. This is the state of Wisconsin versus Napoleon Suarez Llanos, 25 CM 2992. Can I have appearances, please?
State appears by ADA Lillian Nelson.
Mr. Suarez Llanos appears in person with attorney Kathleen Chung. Mr. Suarez Llanos does not speak English. We are here with a Spanish translator who can be sworn.
And Mr. Larson, have you been sworn in today?
I have.
Okay, you're aware you're still under oath?
I am. Yeah.
Very good.
Mr. Suarez Llanos' correct address is on the complaint. He has a copy of the criminal complaint in English. He says he has not been read the charges. My office tells me he is eligible for public representation. And that's the information I have for the court.
Very good. So, Mr. Suarez, you've been charged with 2 counts, misdemeanor battery with a domestic abuse assessment, is the first count. And that count alleges that on or about December 16, 2025, in the city of Fitchburg in Dane County, Wisconsin, that you caused bodily harm to SM by an act done with intent to cause bodily harm to that person without that person's consent. That's a Class A misdemeanor. And upon conviction, you may be fined not more than $10,000 or imprisoned not more than 9 months or both. And further, because the state's alleging that this is a charge of domestic abuse, upon conviction, the court will be forced to assess a fine of $100. And count 2 is disorderly conduct. That count alleges that on or about Tuesday, December 16, 2025, the city of Fitchburg in Dane County, Wisconsin, while in a private place, you engaged in violent, abusive, indecent, profane, boisterous, unreasonably loud, and or otherwise disorderly conduct under circumstances in which such conduct tended to cause a disturbance. That's a Class B misdemeanor, and upon conviction, you may be fined not more than $1,000 or imprisoned not more than 90 days or both. And further, because the state is alleging that this is an act of domestic abuse, upon conviction, the court shall impose a domestic abuse assessment of $100 for the offense. If you're eligible for a public defender, you have the right to have an attorney represent you in a case like that, like this. I find probable cause in the complaint. What are the state's recommendations?
State is requesting a signature bond and no acts or threats of violence towards SMJ.
Y usted firma y promete regresar a corte cuando las fechas de corte y no le puede dirigir actos ni amenazas en absoluto, ni violencia hacia esa persona, en absoluto, nada. Y usted tiene que ser tranquilo y puede regresar a corte. ¿Entiende eso?
We have no objection.
Then I'll order a signature bond with the condition that you make no acts or threats of violence to SMJ. I'll enter not guilty pleas on your behalf, and we are adjourned. And I'm sorry, sir, I forgot, did we get a good address? The address was good on the complaint, I believe. Okay,
That's correct.
okay, thank you. We're adjourned.
Crystal Belmont will be next via this Juneau County jail.
Thank you.
De la mañana o el lunes, ¿ok? Gracias por ver. Thank you, Ken.
Belmont via Zoom.
So I just got an email that we didn't have the Spanish interpreter on. So you might need to let your office know what happened today with VW.
Oh,
I'm
okay.
guessing.
Yeah. We'll do that.
All right, and do we have Ms. Belmont?
I'm here.
All right. This is the state of Wisconsin versus KRYSTAL BELMONTE, 25 CF 2255. Can I have appearances, please?
State appears by ADA Lillian Nelson.
Attorney Kathleen Chung is in court. I'm advised that the individual on Zoom is KRYSTAL BELMONTE, I believe. I have a copy of a criminal complaint bearing her name. I will ask the court to evaluate it for probable cause. From my reading, an officer responded to a scene where an individual who was later identified by the name KRYSTAL BELMONTE or Belmonte was not conscious, was advised by an unnamed individual that a person who was later identified as KRYSTAL BELMONTE may have been in a vehicle. And in that vehicle, paraphernalia and contraband was found. That in and of itself is insufficient to charge that individual who was not conscious and not observed by any law enforcement in a vehicle, much less in any proximity, or that's just insufficient to charge her with a number of felonies. I'll ask the court to evaluate this for probable cause, and I don't know who that person is.
Who, what person is?
The person who's on Zoom.
Okay,
I don't know if she has a copy of the criminal report. I think probably because of the presence here, I can't advise whether they are qualified for public defender, and I don't have information on their address. but it sounds like they may be in custody.
Response from the state regarding the probable cause challenge.
So I guess I'm confused. Is the challenge to the identification or to? Because I mean, what I'm seeing in the complaint here, granted, but I'm seeing that a woman was passed out. EMS and officers responded. Narcan had been administered. The occupant was later identified by a Wisconsin driver's license as Crystal Belmont. There was, just one moment, crack pipe in plain view. There were as a container containing a white rocky substance. Evidence was tested, presumptive positive for cocaine, presumptive positive for heroin. These were all found, I guess, alongside Crystal. So I think that there's definitely sufficient information in the complaint to support probable cause finding for the charges here.
All right, I'll give you the final word, Attorney Chung.
We do not know who saw this. First of all, I should make sure that we have the right appearance. There is no named individual who saw the defendant in a vehicle, much less near these items.
Okay, I'll find probable cause in the complaint. There's enough here. There's an individual identified as Ms. Belmonte, passed out. She's been identified as being in the vehicle by somebody. That will obviously be the state's burden at trial to make that connection. But there's also contraband and drug paraphernalia in plain view. I believe there's enough of a connection there. So I'll find probable cause in the complaint. Ms. Belmonte, you have the right to have an attorney represent you in cases like this. It's unclear if you're eligible for the public defender. So if you'd like, I can give you the public defender's phone number for here in Dane County.
Okay, yeah. Yeah, I
It's-
actually called yesterday and they said after the court hearing that I could go over and apply. But I'm in custody right now, so
Okay,
Could you let me know where you are, please?
I'm Crystal Belmonte.
Thank you. Could you let me know where you are, please?
Yeah, Juneau County in Boston, Wisconsin.
Thank you. In the jail there?
Yeah.
Thank you.
all right. I'll just reiterate, I find probable cause in the complaint. What are the state's recommendations?
The state is requesting a cash bond in the amount of $500 and a condition of no controlled substances or drug paraphernalia without a valid prescription. I would also ask for no contact with the co-defendant, Joseph Holzberger. I would note that Ms. Belmont has a New Lisbon address, I think, hold on. Let me double check this note here because it applies to both defendants and I want to make sure it's correct to Ms. Belmont as well. So it does look like Ms. Belmont does have a bit of criminal history as well, primarily from out of this county, Juneau and other counties, but primarily Juneau County. Some cash at this point seems appropriate to secure her appearance, considering that we don't know of any local connections that she has.
All right, and how much cash was the state requesting?
$500.
Okay, and then the no use or possession of any controlled substances or drug paraphernalia without valid prescription.
That's
And
correct.
no contact with the co-actor.
Correct.
And Ms. Belmonte, I think I got a little bit ahead of myself. Have you received a copy of the complaint?
Yeah, I got it.
Okay. And we have an address for you on Forest Street. Is that still a good spot for you to receive your mail?
Yeah, in the next week, but I'm working to move out, so
Okay, if your address changes, make sure to call our courthouse and let us know that you need to change your address, okay? Or if you have an attorney by that time, you can let your attorney know, all right? Because we'll send address for court to that address, okay? All right. So, Attorney Chung.
With regard to bail, look, CCAP showed that she did have court dates scheduled in that county up there, and then she also has a review hearing and an attorney, so it sounds like she's at least in contact and doing well up there. I don't know, I can't remember if she has cash bail or what's holding her, so it could be DOC. But in any case, she's gonna ask for a signature bond here. Sounds like she's dealing with her issues up there. She's got an address and they know where she is, so I don't think cash bail is needed here. If they want to release her, they know where she is.
All right. I've reviewed, Ms. Belmonte, I pulled up your name in our system and I did a statewide search. There are a number of cases. And I do think at this point, some cash is appropriate. So I'll order $250 cash, the condition that you not use or possess any controlled substances or drug paraphernalia without a valid prescription, and that you have no contact with your co-defendant, Mr. Holtzberger. I will enter not guilty pleas to counts 2 and 3. Will the time limits be kept for the prelim on count 1?
I could have a breakout room with her.
Yeah, we can do that. Or would it just be, given the weather situation, should we just keep the time limits? And if something changes, or?
I haven't spoken, I just don't know what her situation is, if she's,
All right,
I don't
we'll take a
know.
break so you can have
Yeah.
a breakout room.
okay.
Ms. Belmonte, your attorney will speak with you in a moment, okay?
Okay, thank you.
All right, in regards to the time limits,
Thank you. She would like to keep them.
okay, we'll keep the time limits then, and we are adjourned. Thank you.
Next up is gonna be Benjamin Stockwell. Also be a boon from Chippewa County.
And do we have Mr. Stockwell? Do we have Mr. Stockwell? You're muted. I believe there's a gentleman in a green shirt. Are you controlling the release for Mr. Stockwell? So that he can appear? You're muted, sir. You're gonna have to unmute.
I don't know. Yeah, we didn't get a chance to evaluate.
Good.
If you hover over its pad, it's not the last one.
There we go. Do we have Mr. Stockwell?
Yes, Your Honor.
All right. And are you Mr. Stockwell, perchance?
Yes, Your Honor.
Okay. This is the state of Wisconsin versus Benjamin Stockwell, 25 CT 844. Can I have appearances, please?
State appears by ADA Lillian Nelson.
Mr. Stockwell is appearing via Zoom from a location. Attorney Kathleen Chung is present in court. Your Honor, I have a copy of the criminal complaint and I will waive its reading. But I'm not sure if I'm not sure if Mr. Stockwell has a copy. We did not have a chance to evaluate him for whether he qualifies for public representation. I'd ask the court to check on his address as well.
So, Mr. Stockwell, have you received a copy of the complaint in this case? You're going to have to unmute again.
Yes, I have, Your Honor.
Okay. And the public defender here isn't sure if you're eligible or not. So if you'd like to have a public defender represent you, you should reach out as soon as possible to see if you're eligible for a public defender and then take the next steps to get an attorney from there, okay?
Okay, I was actually, I had one question, Your Honor.
Let's just hold on 1 second.
Okay.
And then we have a mailing address for you on Rock River Drive. Is that still a good spot for you to receive your mail?
That's correct, Your Honor.
Okay, so these hearings are recorded. Anything you say could be used against you. So I want to caution you about talking about the facts of this case, all right? But if you have a question, I'll listen to it. Your attorney might jump in and stop you though.
Okay, I was looking to plead guilty, Your Honor, today.
Okay, I'm going to stop you there. I'm not going to accept a plea today, all right? So that'll be a discussion to have with your attorney moving forward, okay?
Okay, thank you, Your Honor.
I find probable cause in the complaint. What are the state's recommendations?
It's just one moment. I just need to take a quick look at this case because there are no bail notes. State would request. Just one moment. I guess the state would request a signature bond. I don't have any information right now about prior failures to appear. If they exist, I don't have time to look them up right now. This is an non-violent offense, so I think an OWI would be okay. I mean, signature bond would be okay. I believe he is on supervision as well. As for conditions, I would ask for no driving, so no operating a motor vehicle, no controlled substances or drug paraphernalia without a valid prescription, and pretrial services to monitor that.
And Attorney Chung.
I don't think we'll object to that.
All right.
You have no objection to Mr. Stockwell? The state is offering that you would be released on what's called a signature bond with your signature only, with a condition that you have no drugs, that you operate no vehicles, you do not drive, and that if you were released, that you would be subject to a monitoring by Dane County Pretrial Services. Sounds like you're under supervision already, so if you like, I'll object to that for the court. Since it sounds like he may be in a different county, Your Honor, I'm gonna object since he's on supervision. I bet you that's already a condition.
Okay.
Is that fine with you, Mr. Stockwell?
You're muted again, sir. We're just hearing background noise, so we're manually muting you. So if you could unmute, there we go.
So I'm currently incarcerated in the GOC right now for 18 months, so I won't object to a signature bond, but I would just like to.
Okay, that's all I'm gonna ask. That's fine. That's all I wanted to know. I guess in that case, I'd almost suggest cash, but will not object.
Okay, response from the state?
I would maintain my request for a signature bond. I don't think it's appropriate to give him a cash bond just for the purpose of accruing credit on his case.
We didn't.
Well, I know, I'm just saying, I think a signature bond is appropriate. So with the requested conditions, I guess, yeah, I would maintain my request for all the previously stated conditions. If he's released at any point, I think pretrial services would be appropriate.
All right. What I'll do is I'll order a signature bond with the conditions that you not operate a motor vehicle. I'll also order that you not use or possess any controlled substances or drug paraphernalia without a valid prescription, okay? I will enter not guilty pleas on your behalf. And we are adjourned. Thank you, sir.
Thank you, Your Honor.
Kitchen will be next to you, Zoom.
Where's it from? Just write it down. Yeah, where? Where's it from? Oh, he's here?
He's in custody. This is secretary.
Okay, come here.
These are completely different charges.
So this is kind of a bit of a wackadoodle thing. So there's a group file, there's a bond violation, and he got that case got declined though, so he's gonna be released from custody on that one. But the state filed, and I believe it was a resisting.
I have one
Resisting
complaint.
and resisting.
Yeah, that's all I
Yep.
have. Okay.
And so that's different than the other one. So we're gonna do the IA on the 25 CM 3000. He'll be released from bail on the group file case.
Your video went out.
And he's appearing by Zoom.
Yeah.
Okay. All right. And do we have Mr. Kitchen?
Yes, I'm here.
Very good. This is the state of Wisconsin versus JAVONTE Kitchen, 25 CM 3000. Can I have appearances, please?
Sorry, state appears by ADA Lillian Nelson.
Attorney Kathleen Chung is in court. There's an individual appearing by a food slot. I have a copy of a criminal complaint bearing the name JAVONTE Kitchen. I have a piece of paper that indicates that that individual is eligible for public representation, and a complaint bearing that address is accurate. The complaint I reviewed contains probable cause.
So you have the right to have an attorney represent you on a case like this, okay, Mr. Kitchen? I find probable cause in the complaint What are the state's recommendations?
Just one moment. I apologize. I was,
Nope, if you need a moment, feel free to take it.
my goodness, now okay, I apologize. Okay, so the state is requesting a signature bond on this case and no contact with Tony L.
TONY, L as in Larry.
Yes.
Okay, in response?
Are you Mr. Kitchen?
Yes, ma'am. And you said I can't have contact with TL?
The state is recommending that you be
No, that,
released,
yeah,
sir.
that's
Is that okay
definitely,
with you?
yeah, that's definitely fine with me because,
Okay, that's all I'm at. Nope, that's all I'm asking. No need to say anything more. No objection.
okay.
Then I will enter not guilty pleas on Mr. Kitchen's behalf. I'll order a signature bond with the condition that you have no contact with Tony L. And Mr. Kitchen, I'm going to release you from bail in the other case. That's the group file case that had different conditions than and involved a different scenario than this case. So if you have any questions about that,
Wait,
make sure you reach out to your public defender when you get somebody assigned to you. All right. And we are adjourned. Thank you, sir.
Next, Lee and Maria Antone.
Does anybody need a minute to get set up? Okay, so we'll just take a brief moment.
This is another Zoom. She is before.
FO case. Yeah. So we'll just have the forfeiture track along.
You address the bail conditions in the.
Address them. She was released from bail.
For Mr. Kitchen was no contact with Tony L.
Yeah, did you order those?
Yeah,
Oh,
it was a
signature bond.
signature bond and no contact with Tony L.
Yep.
Sorry.
Was that case.
Yep.
Cases are already.
You're good now. Yeah.
I think we're good.
I don't hear. So have the room. When I stand out right now, you'll listen.
This is the state of Wisconsin versus Maria Antone, 25 CM 2991 and 25 FO 2510. Can I have appearances, please?
State appears by ADA Lillian Nelson.
Thank you. Ms. Antone appears in person with attorney Kathleen Chung. She is eligible for public representation and has a copy of her criminal complaint, which bears an address that needs changing. The correct address where she can receive mail is N 7312 Ho Chung, one word, Road, Wittenberg, Wisconsin, WITTENBERG. The zip code is 54499. I have a copy of the criminal complaint and will waive its reading at this time. Thank you.
All right, you have the right to have an attorney represent you on a case like this. You're eligible for a public defender, so hopefully they get somebody appointed for you soon. Sometimes it's a few weeks, sometimes it can take a few months. Just hang in there, okay? I find probable cause in the complaint. What are the state's recommendations?
State is requesting a $500 cash bond, condition of no contact with Robert H. and no use or possession of any dangerous weapons. I note Ms. Antone is on probation for a crime where Robert H. and his family were involved. This new offense is also Act 3 eligible. Those two factors, I think, merit moderate cash bail.
What was the recommendation, please?
$500, no contact with Robert H. and no use or possession of any dangerous weapons.
Okay, so she is on supervision and I'm gonna ask the court to put low cash bail. Reading the complaint, I think it's clear that there is I was gonna ask for the court to dismiss it, but I think that there's a clear indication here that there's a dispute going on. The witnesses indicate a definite implication that RLH was coming at her. So I'll ask the court to impose low cash, let her agent, who's gonna know the facts here, address it. If the agent thinks that she should stay in, let's let her stay in. I'll ask for low cash, $100 to $200.
Right. I'll order $500 cash. Conditions that you have no contact with Robert H. and that you not use or possess any dangerous weapons as that term is defined by statute. Do you need any,
Pardon?
do you need any clarification about that last one, what no dangerous weapons means?
No, you're.
Okay. I will enter not guilty pleas on your behalf. And we are adjourned.
Sorry, did you order the, sorry, I was,
fine.
did you order the 500 or a signature bond?
500.
Okay, thank you. Notes.
Thank you.
Tam is next. Giancarlo Tam.
I don't see that it's flagged for one.
Tam? Yeah, no, please.
This is the state of Wisconsin versus Giancarlo Tam, 25 CM 3001. Can I have appearances, please?
State appears by ADA Lillian Nelson.
I'm gonna ask for an interpreter. I'm advised by my client that he doesn't speak English.
Okay, then you'll return to, yep. Well, yep, you're right. So we'll adjourn until we can get an interpreter. All right.
Thank you.
Commissioner, just so all the parties are aware, the public safety assessment on Mr. Tam has just been printed out. It should be coming out of the printer.
All right, I see it in the court file.
All right, thank you.
It is stand.
Maybe if we have an interpreter left.
Well. Or reach out if.
Yeah.
BANKHEAD, did you make that? While we wait.
BANKHEAD. Are you ready? Okay.
BANKHEAD.
This is the state of Wisconsin versus Allen BANKHEAD Jr., 25 CF 2886. Can I have appearances, please?
State appears by ADA Lillian Nelson.
Thank you. Mr. BANKHEAD appears in person with attorney Kathleen Chung. He is eligible for public representation and has a copy of the criminal complaint. But the best address to use for his address should be the Job Center at 1819 Aberg Avenue in Madison. It's 53704. He has a copy of the criminal complaint if I didn't say so. I will ask the court to take a look at it. What I'm looking at is the allegation or the assertions within the complaint that the law enforcement could hear the defendant pushing items up against the door along with TV, the subject of the warrant. I'm not sure how they can hear who is pushing items or who is flushing things.
Well, I think it's circumstantial. They heard people pushing items up against the door. There were 2 people found. It's possible they heard two different things occurring, which would indicate two different people were doing those things simultaneously or relative in time where only one of the two people could be doing each of the things.
That's not what was in the complaint, but that's,
I believe it's a reasonable inference. I'll find probable cause in the complaint. You're eligible for a public defender, sir. You have the right to have an attorney represent you on a case like this. They'll work on getting somebody appointed to your case. What are the state's recommendations?
Yes, just one moment. The state. And I apologize, this is for 25 CF 2886, correct?
Correct.
Okay, signature bond and no contact with Terry Brooks. TERRY.
we have no objection.
And given the allegations, I think there's a need for cash in this case. I'm thinking doesn't have to be a grand amount of cash, but some cash is necessary. Does the state want to be heard on a response?
I would need to look a little bit closer at the case. I'm going off the bail notes.
Right.
I, at least for my very brief review right now, I'm not seeing any prior failures to appear. But I would need to look a little further into this. I don't really have any information.
And Attorney Chung?
I also saw no prior failures to appear. This is not an Act 3 eligible case. I think the purpose of bail is to see whether, or to ensure Mr. Bankhead's appearance in court. So I am gonna go back to CCAP and see where the concern is coming from. I did not see a significant record here, so let me just go back, given the state's recommendation. So I'm gonna go back and look here.
Yeah, I'm taking a look at what I have right now for his record, and it's quite dated. I'm seeing some cases from 2012, 2011.
Well, the basis for my thinking of cash is the nature of the charges and what's been alleged. It's alleged that, the police show up and Mr. Bankhead and somebody else barricade the door with a number of very heavy objects. They're heard possibly flushing things. There's multiple warnings to come to the door and deputies aren't let in. There's a story given about where the other person is that turns out to not be true. It seems like Mr. Bankhead isn't willing to, at least at this point, as far as I can tell, avail himself to the court process.
Just hold on a second, yeah. So, if we can be heard.
Yep.
So of course, these are allegations. Mr. Bankhead is of course innocent of this charge, although I'm not sure if he's enjoying that presumption at this time. He has not been convicted of a crime for a very long time. There's no one, as I said, there's no proof here that he has done much of anything. He is innocent before the court and has almost no record of non-appearance. The allegation, of course, of the other individual that we had before us just very recently, who was charged with his 7th and 8th operating while intoxicated case. He is in custody. He has violated that charge so many times, and very recently was given a signature bond, and he was ready to plead guilty, thus indicating he almost certainly did that crime. Here we have a very different individual who appears before the court. A signature bond is definitely appropriate in this case.
All right. And any position from the state?
Just one moment. No, I have nothing to add.
Okay. I'm going to order $250 cash with the condition that you have, Mr. Bankhead, that you have no contact with Terry Brooks. The other individual was being held regarding some other charges as well. There's no presumption here that Mr. Bankhead is guilty. I'm not imposing a sentence. I think some cash is necessary to make sure that he appears for court, though. So that'll be the order regarding bond. I'll enter a not guilty plea as to count 2. Regards to the time limits for the preliminary hearing.
They're not waived.
All right, we'll keep the time limits in place then, and we are adjourned. Thank you.
Falcon is next, Davion.
Falcon? Oh, Broughton?
Broughton.
Okay.
Oh.
This is the state of Wisconsin versus JAVION Broughton, 25 CF 2893. Can I have appearances, please?
State appears by ADA Lillian Nelson.
Mr. Broughton appears with Attorney Kathleen Chung. He has a copy of the criminal complaint. I am advised by this piece of paper that I have that he does have private counsel, but he is here without him, so I will represent him here for this hearing. I don't know therefore whether he qualifies, so he is being given information about applying for public representation. I don't have information on that right now. One moment. Is there a problem number? That's just it. So a correct address for him is 154 Kennedy Heights, Madison. 704 53704. 154. I think I said he has a copy of the criminal complaint. I am going to ask the court to evaluate it for probable cause. It's lengthy and it's very convoluted. As far as I can tell, every other individual who is interviewed here admits to being in the car and or participating in either asking for DJS for their items or participating in handling the weapon, knocking the weapon, or otherwise touching the weapon or asking for demanding the stuff or your stuff or your SH. But except Mr. Broughton. Therefore, I don't see the probable cause here. I'm going to ask the court to evaluate it for probable cause. He's the only one who doesn't say he was there.
All right, response from the state.
Yes, so first of all, I'd like to note that just because someone doesn't admit to a crime doesn't mean that they did not commit that crime. What we have in this complaint is a group of 6 or 7 juveniles are people who were the part of this what we know now to be a drug rip, armed robbery. Mr. Broughton was seen on the video wearing the same clothing that he was seen in another video wearing at his high school, wearing the same sweatshirt, which had an identifiable logo on it, was also pointed out by another co-defendant named by name, I believe as JAVION, by the co-defendant Juan Pablo Elizondo, who indicated that it was Mr. Broughton who was with him on that date and who was present at the robbery with him. There's furthermore, from one of the juveniles who was associated with this robbery, a ChatGPT entry essentially describing the rip itself, indicating that there would be several different roles to this robbery, that one person would facilitate the sale, one subject would grab the drugs, 2 would fight with the sellers if they object to the robbery, and then whoever has the gun would display it to enforce the robbery. Based on the information contained in the complaint, it seems that Mr. Broughton was part of this group that was well aware that a robbery was going to take place. That had been planned. The evidence indicates all 5 co-defendants were aware that a robbery was going to occur and that one of the participants was armed. So I think while this complaint is a bit messy, it's difficult to read and somewhat convoluted. I think that in terms of probable cause, there's sufficient evidence there to tie Mr. Broughton to this incident and indicate that he had knowledge that this incident was going to occur.
Right, I'll give you the final word.
There is no video of the actual incident. The Nest camera that I'm not sure which video there's a lot of different video. There is video of Mr. Broughton in the school. There is the Nest, so there's different videos. I'm not sure what the other video she's referring, or the state is referring to. The video of the Nest camera does not show that individual's clothing. There's another video later that shows a person wearing that clothing that is later in that evening or that same day. As far as the ChatGPT, I believe that comes from Mr. JP's phone, not including my client. So well, nevertheless, that's our response.
I wasn't able to review this before the hearing today, as this case was filed near in time when we were scheduled to start.
I don't know if it's helpful, but I think the main actor on the Nest was the long-haired individual, which is, I could be mistaken about what the state was referring to.
So just breaking down the complaint a little bit. There's officers are dispatched to a hospital. There's a gunshot victim. They interview the victim and I think people who are present with the victim. Victim describes what's called a drug rip, in which the victim is shot. There's scene identification and video surveillance. There's the Nest recording. There's an interview with a witness. Then there's some interviews conducted. There's some review of social media. Describes more interviews, an arrest of one of the co-defendants. Description of what happened. There's on page 11, the last paragraph in that section during Detective Hogan's interview. And it describes that JAVION is, the interviewee describes that JAVION's present during the course of the incident, and JAVION's clothing matches clothing from the school security cameras matches what he's wearing in the surveillance footage. There's more interviews, a search of a residence, cell phones are searched. There's a pen register conducted. Mr. Broughton's interviewed and doesn't provide anything inculpatory. But he is identified as being present during the course of this. Believe somebody matching his description. is identified by the witness with the Nest surveillance, at least generally. It's reasonable inference that, you know, this, it looks like from the co-defendants that, this, what they're going to do is being discussed beforehand. Mr. Broughton's present during it. He, leaves with everybody. I believe that there's probable cause here, on both counts, as a party to a crime. So I'll find probable cause in the complaint. What are the state's recommendations?
Yes, before I make my recommendation, I have a statement from the victims that they would like me to read. It's short. They say ensuring the safety of the victim and their family, including our community, should be priority. The trauma and harm that the victim and his family experienced are significant, and a high bail not only reflects the severity and seriousness of the crime committed, it also provides a sense of accountability. That's the end of their statement. As for our request, we are requesting a cash bond in the amount of $1,500. No contact with JAVION S, that is DAVIAN, or any member of their family. No contact with AGL or any member of their family. No use or possession of controlled substances or drug paraphernalia without a valid prescription. And no use or possession of dangerous weapons. This is an Act 3 offense. As I noted before, the evidence points to a group of 5 young people knowingly setting up a robbery with a drug deal as a pretext. The victim is shot once, and emergency surgery is required to remove the bullet. It damages one of his lungs, liver, and possibly his stomach. I would note Mr. Broughton does seem to be not one of the most involved people here. I don't believe he was in the vehicle, if I'm not mistaken, but all the available evidence indicates that all 5 co-defendants were aware that a robbery was going to occur and that one of the participants was armed. So some cash bond is necessary to account for the Act 3 nature of this offense and to better ensure appearance in court. But I don't think it needs to be anything astronomical, given that we don't believe he's the one who actually shot.
Okay, response?
So I think it's clear that I think the state is correct that all of the actors who were in the car and have spoken, and including the people who had the gun, are not charged and are free and out. So they evidently are not a danger to the community. And it is this individual who perhaps the state believes may have been ancillary involved, and I think that the probable cause is very weak here. So his family is obviously qualifies for, the attorney did not show, I don't know if they were retained or not. I think that low cash may be appropriate given the charges. His family cannot post much. I'll ask the court to consider low cash. Obviously, the charge is serious. If the court thinks that $1,000 is necessary, $500 is necessary, they'll try to get it together. But this is a difficult time of year. I'm gonna ask the court to consider the lowest cash possible. There is no question that even if the allegations are true, he is the least culpable of all these individuals who are otherwise not charged and evidently not a danger.
All right, response from the state?
No, I don't have anything to add. I think that the amount of cash we've requested is appropriate given the seriousness of this offense. And I do think it balances the fact that Mr. Broughton was not the main person here.
All right, I agree with the state. Least culpable is on a spectrum. One of the co-actors is charged with a first-degree intentional homicide. Mr. Broughton's charges don't rise to that level. His participation doesn't appear to rise to that level. But nonetheless, the charges, the allegations by the state are very serious. We're in Act 3 territory here. So I'm going to order $1,500 cash, that you have no contact with Davian S. or Davian S.'s family, that you have no contact with AGL or AGL's family. I'm going to order that you not use or possess any controlled substances or drug paraphernalia without a valid prescription. I'm going to order that you not use or possess any dangerous weapons. Do you understand what no contact means?
So he is asking me, and it's a fair question. He's not sure who those individuals, or that he can identify those individuals or their families Family is really broad.
Okay.
So how will he obey those conditions?
Response from the state?
I guess
Or identify those individuals? Yeah.
I don't have a answer for that. I guess what I would ask is that he not knowingly contact or make contact with any member of the family. If there's incidental contact in public, I can't control that. If no one is aware of each other, then I guess there's no issue. But I think this is aimed primarily at preventing any sort of intimidation or anything like that.
And I think perhaps more, my wording wasn't narrowly tailored enough. So I'll say no contact with any immediate family. So that's like mom, dad, siblings, things like that, okay? You may not know who those people are, which means no contact with them should be really easy. These are felonies, so you have the right to have a preliminary hearing within a certain amount of time. Those time limits be kept or waived?
Well,
I can't hear you.
Let's not waive them for now.
Okay, we'll keep the time limits in place then, and we are adjourned. Thank you.
next week, Whitehead, he has zero.
Yes.
We're being advised to keep the food lot closed. Try to afford that food that day.
Okay.
So they'll just be here to the bill.
So there is an interpreter that has been, with for Tam. Well, that's to do with the best of the range.
So who was this next co-defendant? I mean, next defendant, White? Okay, thank you.
This is the state of Wisconsin versus Luke Whitehead, 25 CF 2888. Can I have appearances, please?
State appears by ADA Lillian Nelson.
Thank you. I'm sorry, I did not have an opportunity to review this one, so give me one moment. I do see that this is Attorney Kathleen Chung in court for this hearing. I do see an individual appearing on Zoom, and I think we were advised that that individual, there's some communication issue, so I'll ask the court to inquire.
All right, do we have Mr. Whitehead?
Yes, I'm here.
Okay, can you hear us all right, sir?
Yeah, I can.
All right, have you received a copy of the complaint?
Yeah, just now.
Okay, I'm not sure if you're eligible for a public defender or not, but you do have the right to have an attorney represent you on a case like that. That'll be Attorney Chung today, all right?
Okay.
Yeah, we evidently did not have this must have been a late one. We did not have an opportunity to evaluate whether he's eligible, so I'll ask him to be provided with that information, and maybe the court could, looks like we don't have an address either.
So we'll get you information on how to contact the public defender. They can be reached by phone if you'd like. And do you have a spot where you can receive mail, sir?
Yeah, the county jail, here at the county jail.
Okay. We'll update your address to there. If you leave, just make sure that you're also changing that mailing address, okay?
Okay, thank you.
All right. I find probable cause in the complaint. What are the state's recommendations?
The state is requesting a cash bond in the amount of $5,000, conditions of no dangerous weapons and not to be at any residence where firearms are kept. I would note Mr. Whitehead has a long criminal history and seems to be in jail more than out of jail. He was convicted of this exact same charge in May of 2024. Cash is necessary to protect the community and make him come to court since he was yelling during this incident that he would not go back to jail and that the officer would have to shoot him. So I think that taking all these factors into consideration, a substantial amount of cash bond is appropriate.
Attorney Chung.
I do remember looking up this case just a little bit. I think this individual is already represented by attorney from our office, so it's likely that he will be qualifying, especially given his custody status. It does seem that cash bail is likely to be appropriate here. I'll ask for the court to consider lower cash bail. It sounds like he's indigent, so $5,000 seems excessive. I'll ask the court to consider low cash bail.
All right, Any response to the state?
No, I would maintain my prior request for cash.
All right. Um. Given the allegations and the lengthy criminal history, I think a high amount of cash is appropriate. I'm going to order $4,000 cash with the condition that you not use or possess any dangerous weapons and, that you not reside any place where firearms are kept, excluding the Dane County Jail, okay? I will, this is a felony, so you have the right to have a preliminary hearing within a certain amount of time. Will the time limits be kept or waived?
At this time, let's keep them.
Okay, we'll keep the time limits in place then. I believe that's all I can do for the party, so we are adjourned. Thank you, sir.
Mr. Christopher Brewster, back via Zoom.
So our inspector is actually, it's on Tuesday, operations in any moment.
Yeah.
Oh, it's here.
Oh,
So who are we doing next, Tam? Or-
Yes, ma'am.
Okay.
yes.
You did access, huh? So you didn't think you did that?
No, I didn't.
This is.
We'll just do restate.
Okay.
Yeah, well, we can try.
This is the state of Wisconsin versus Christopher Breister, 25 CM 2999. Can I have appearances, please?
State appears by ADA Lillian Nelson.
Attorney Kathleen Chung is in court for Christopher Breister. My office has evaluated that individual and found that they are eligible for public representation. I have a document showing that the address on the complaint is accurate. I have reviewed this complaint and did see that probable cause was there, and there's an individual appearing by Zoom. I'll ask the court to inquire.
All right, do you have Mr. Breister?
Hello.
Hi. I believe we have Mr. Breister. You have the right to have an attorney represent you on a case like this, all right? You're eligible for a public defender. They'll work on getting somebody appointed for you as soon as possible. It's a process that can take a little bit though, so hang in there, all right? I find probable cause in the complaint. What are the state's recommendations?
State is requesting a signature bond and a ban from the DMV at 2344 South Park Street.
Your Honor, I'm gonna actually take my comment back. I apologize. I do want the court to look at this for probable cause. When I read this, it sounded like somebody went into a DMV and swore. And I understand that that's not appropriate, but people are frustrated at the DMV. I just don't know that that's a crime. So I'll just have the court take a look at it.
All right, any response from the state?
I'm reading the complaint right now. He was throwing things and causing a scene. He wasn't just swearing, he was throwing things and causing a scene, it seems. He had an outburst where he called someone a effing bitch and was acting loud and threatening, disturbing the customers and frightening the people inside the DMV. He was just generally creating a disturbance. I think that meets the statutory definition of disorderly conduct. I think that's sufficient here.
All right, and I'll give you the last word, Attorney Chung.
One moment, please. Throwing stuff and causing a scene, I guess is just too vague. No, nothing further.
Well, it's not just that. I'm looking at page 2, the paragraph right before the heading that says contact with defendant. I believe it's AMC who makes this statement. She specifically stated that the defendant was wearing a black jacket with a backpack on and had bleached blonde hair. She specifically stated that she believed his behavior was consistent with someone that was about to take a swing. Between the swearing, the loudness, I believe I read there was a pencil broken.
That was at a previous situation, Judge. That was not today.
That's correct. That pencil breaking was an incident that happened a year prior.
Oh, I see.
Allegedly,
Yep.
but not to, this is not alleged within this complaint.
Okay, there's certainly enough here for probable cause. I'm gonna find probable cause in the complaint. What are the state's we have the state's recommendations. On Mr. Reister, signature bond with the ban from the DMV at 2334 South Park Street.
Mr. Brewster, can you avoid the DMV on South Park?
What was that?
Can you stay away from the DMV on South Park?
Yeah. Yes.
Okay, if you go there, that'll be bail jumping. Do you understand?
Yes, ma'am, it won't happen. I haven't been in trouble in 10 years, so.
Thank you. No objection.
All right, I'll order a signature bond with the ban from the DMV at 2334 South Park Street in 2344 and 2334.
Sorry, it's 2344.
2344 South Park Street in Madison. I will enter a not guilty plea on your behalf, and we are adjourned. Thank you.
Next is Pam, we'll try this one again.
I have the.
Pam.
Well, I guess it's really because he can.
And do we need the interpreter for the live stream?
Yes.
All right, and then if we, Mr. Larson, if you could interpret for the live stream as well, just to be safe. Thank you. Actually, this is resisting obstructing. I don't think there would be a witness on a case
Or a
like this.
victim either.
Yeah, or I'm sorry.
There's no victim on this case.
Yeah, I'm sorry. We just had an issue with somebody else. All right, this is the state of Wisconsin versus GIANCARLO TAM 25 CM 3001. Can I have appearances, please?
Yes.
State appears by ADA Lillian Nelson.
Mr. Tam appears in person with attorney Kathleen Chung
Kathleen Chung.
and an interpreter who has been sworn. My office says he's eligible for public representation. He has a copy of the criminal complaint in English. His correct address is on the complaint. I think the criminal complaint may contain probable cause, but now, given the language barrier, I'll ask the court to evaluate it for probable cause.
How does Mr. Tam's ability to understand English impact the what's within the four corners of the complaint?
La capacidad del señor Tam para entender inglés, ¿cómo eso impacta la información en el procedimiento?
I think that he maybe didn't understand the question.
Yo creo que él no entendió la pregunta.
Who didn't understand the question?
Mr. Tam.
No, I was asking you, ma'am.
Right, I understand. I think that it's possible that in this case, he did not understand the question and perhaps he gave a proper name or answered the question accurately that he thought was being asked of him.
So you're asking me to make a competing inference, or are you basing this on the four corners of the complaint? Or are you asking me to impute information about his ability to speak English?
I didn't understand the last question, just to evaluate the complaint for a probable cause.
Okay, I find probable cause in the complaint. You're eligible for a public defender, sir.
I'm sorry, I had two people talking at once. You want me to interpret, or I didn't catch it all, I can ask them to repeat.
I find probable cause in the complaint. You're eligible for a public defender. And what are the state's recommendations for bail?
The state is requesting a cash bond in the amount of $300 No specific conditions. The basis for this request is that Mr. Tam lied about who he was, and law enforcement did not discover this lie until he was booked into the jail and fingerprinted. At that point, law enforcement discovered that Mr. Tam was on probation and was in violation of the rules of probation. This seemed like a concerted effort to avoid the criminal justice system, and some amount of cash seems reasonable.
Attorney Chung?
May I ask if there's a DOC hold?
I see there was a DOC hold, but my notes indicate that it was dropped per the agent as of today's date.
I wasn't sure, that's what it appeared to me. One moment, please.
Very good.
No tengo idea pero yo mentí porque solamente quería que yo entré un otro documento tenía después lo mismo que dicen, ¿no? Yo hice otra cosa mal. I don't even think I should have it. Let's speak to something. Me habían dado permiso a mí en scout.
Okay, thank you. Mr. Tam has no ability to post cash at this time. Consistent with his address, he has no housing. The PSA that I have shows a recommendation of a signature bond, the evidence-based tool the court has asked for and does have in the record. It appears that he is on supervision, and his agent from the Department of Corrections did have a hold. So he has been in custody for some time. And now that hold is dropped, meaning that the agent at the Department of Corrections believes that they are in sufficient contact with them, Mr. Tam, to release that hold. If cash is imposed, Mr. Tam will remain in custody until he is appointed an attorney who is able to bring a bail motion, which will not happen soon. Therefore, he will remain in custody for some time on this case, regardless of his agent's situation. We'll ask for the court to consider first a signature bond, as it should. This is clearly not a violent offense. And we'll ask the court in the alternative to consider low cash because he cannot post any.
Any response from the state?
No, I don't have anything to add. I would rely on my prior argument and maintain my request for cash.
So, Mr. Tam, I'm going to order a signature bond today, but you need to show up for court when court is scheduled. Do you understand that? Okay. You also need to follow the law. Those are standard conditions of bail. Okay, so I'll order a signature bond. With the standard conditions, I'll enter a not guilty plea on your behalf. And we are adjourned. Thank you.
Daniel is next. The guy, Daniel.
Which one was
It was an attempt.
Oh, there's the opposite. I was like,
Yep.
which one is coming?
Daniel. Daniel.
Oh, Daniel's the last name. Sorry.
Sakai.
The guy.
Right.
The guy.
This is the state of Wisconsin versus Sakai Daniel, 25 CF 2891. Can I have appearances, please?
State appears by ADA Lillian Nelson.
Mr. Daniel appears in person with attorney Kathleen Chung. His correct address is listed on the complaint. Our office says that he qualifies for public representation. He has a copy of the criminal complaint. I think it has probable cause, so we'll waive its reading.
All right. So if you have the right to have an attorney represent you in cases like this, you're eligible for a public defender. They'll work on getting somebody appointed for you, all right? I find probable cause in the complaint. What are the state's recommendations?
State is requesting a cash bond in the amount of $1,000 and conditions not to operate a motor vehicle and no use or possession of alcohol. I know Mr. Daniel now has 5 open cases, 4 of which are felonies. He keeps driving and keeps consuming alcohol despite having posted a total of $1,250 in cash. He simply will not follow court orders and doesn't believe he's doing anything wrong when he fails to follow court orders. So at this point, cash is appropriate.
All right, Attorney Chung.
So the last individual who had a 7th and 8th OWI and was now charged with another 7th and 8th OWI got a recommendation for a signature bond.
I'm going to interject. That individual was being held on something else as well. So it's not an analogous situation, but I understand your point.
I'm simply making my bail argument here.
Very good.
And now we have an individual who is alleged to, I think he's on his OWI 2nd, if I'm not mistaken. But I could be wrong about that. But in any case, he does have lower level OWIs. The allegations in this case is not an OWI. Although there are facts that could support that, that is not charged within this complaint. Additionally, the facts here are that the individual or that the defendant got out of the car and went into a hotel room, I believe. There was some type of backing in. The driving was extremely limited as alleged, and of course he's innocent of that. I think the allegations are that he has an OWI 2nd pending and that the driving was extremely limited. So I'm going to ask the court, $1,000 is awfully high. I'm going to ask the court to consider lower cash. This is not an Act 3 eligible case. There is no violence alleged. He was not uncooperative. I don't see any allegations that he's not showing up to court, or I didn't hear that in the argument from the state. So will he show up to court? That has not been argued that he's not showing up to court. There is an allegation here that he violated bond conditions in a non-violent fashion, that he answered a door when police knocked, that there's no allegation that he gave a false name. There's no allegation that he ran or in any way resisted officers. There's an allegation that he violated bond in a non-violent manner. I think low cash, or certainly a signature bond, should be considered. This is a low-level crime. There's no violence. I think a signature bond is appropriate in this case.
Any response from the state?
I think a signature bond may have been appropriate several cases ago, but he is continuing to violate conditions of bond. He has zero regard for his conditions of bond. Bail can in part be set, prior violations of bond can be considered in setting bail. I think at this point, we've reached the point where just $1,000 of cash is appropriate. He's picked up 5 open cases now. Enough is enough.
I agree with the state. Mr. Daniel, your exposure is increasing, and it's a problem for this court when conditions of bond are not being followed, allegedly. It may be in a limited fashion. The conditions may have been violated in a non-violent fashion, but violations are violations. So I'm going to order $1,000 cash, that you not operate a motor vehicle, and that you not consume or possess any alcohol. I will enter a not guilty pleas to count 1. Counts 2 through 3 are felonies. Will the time limits be kept or waived?
I'm sorry, you said $1,000 cash and?
That Mr. Daniel not operate a motor vehicle and that he not consume or possess any alcohol.
We'll waive the time limits.
Okay, we'll waive the time limits for the preliminary hearings hearing, and we are adjourned. Thank you.
What's his tax? Money, what?
This is the state of Wisconsin versus Cumani Woods, 25 CF 2892. Can I have appearances, please?
State appears by ADA Lillian Nelson.
Mr. Kamani Woods appears in person with attorney Kathleen Chung. He is eligible according to our evaluation for public representation. His correct address appears on the complaint, which he has a copy of, and we will waive its reading.
Right. You're eligible for a public defender. You have the right to have an attorney represent you in a case like this. They'll work on getting somebody appointed for you, okay? I find probable cause in the complaint. What are the state's recommendations?
The state is requesting a cash bond in the amount of $750, condition of no firearms, no weapons in general, and no controlled substances or drug paraphernalia without a valid prescription. I would note Mr. Woods was released on a signature bond in November with conditions not to possess any controlled substances or any dangerous weapons. Here he is just over a month later in possession of a firearm and controlled substances. He's clearly not following very basic court orders, and now with the heightened likelihood of incarceration, there's also a heightened incentive not to come to court, so some amount of cash it seems appropriate.
And Attorney Chung?
Thank you. Mr. Woods is in great contact with his attorney, and his attorney knows all about this case. He's already spoken with his attorney about it. There's every likelihood that he's coming to court because he's already talked to his attorney about it. So I'm gonna ask the court to consider low cash in this. He can't post anything, so this will be a significant burden on him. I'm gonna ask the court to consider $500 or less.
Any response from the state?
I would maintain my request for the $750. I don't have any additional argument to make.
Right. From my perspective, anytime there's a gun involved, that kind of makes my ears stand up. I've considered signature bond. I've considered something higher than what the state's recommended. I think the $750 cash is an appropriate amount. I also order that you not use or possess any dangerous weapons, as that term is defined by statute, and that you not use or possess any controlled substances or drug paraphernalia without a valid prescription. These are felony charges. Will the time limits be kept or waived?
Kept them.
Okay, we will keep the time limits, and then we are adjourned.
And just to confirm, Commissioner, did you order the 750?
Yes.
Okay, thank you. Want to make sure my notes are correct. Thank you.
Miller would be nice, David Miller. I don't have.
Miller? Very good. Let's see the chair. Very fun.
This is the state of Wisconsin versus David Miller, 25 CF 2895. Can I have appearances, please?
State appears by ADA Lillian Nelson.
That's one.
Just the. So this is. Yes.
Mr. Miller appears in person with attorney Kathleen Chung. A better address for him is P.O. Box 212, Cottage Grove. The zip code will be actually 53537, is that right?
535.
It is 53527. I thought that's right. He does qualify for public representation. We have a copy of the criminal complaint. Each of us does, and we'll waive its reading.
And I'm sorry, did you say that Mr. Miller is eligible for a public defender?
Yes, yes.
Okay.
Thank you.
You have the right to have an attorney represent you in a case like this. You're eligible for a public defender. They're gonna work on getting somebody appointed for you, okay? It's a process that can take a few weeks. Sometimes it can take a few months, okay? So just hang in there. I find probable cause in the complaint. What are the state's recommendations?
State is requesting a cash bond in the amount of $1,000. Conditions not to operate a motor vehicle, no use or possession of alcohol, no controlled substances or drug paraphernalia without a valid prescription, and if he posts pretrial services to monitor the alcohol and drugs. I would note Mr. Miller has a pending OWIS 7 in Columbia County. He here admits to drinking and using cocaine. He's now facing significant prison time if convicted. We're not sure if he has a permanent address. We're not aware of one. So for all these reasons, the state believes that cash is appropriate to ensure appearance at future court proceedings and also to ensure the safety of the public.
Attorney Chung?
Thank you. We're gonna ask the court to consider lower cash in this case. He does know about his case in Columbia County, and I think he's reporting that he is showing up there. Mr. Miller's obviously got significant health issues here. He called the police himself, according to the criminal complaint, and he was, although there may have been some, I would say, allegedly some kind of mental issues, or in other words, difficulties, but he was not, I think, intentionally, allegedly uncooperative with the police. In other words, he didn't give a false name. He didn't run from them, although it appears that maybe he made some reports according to the complaint that were not accurate. It doesn't appear that he was, for example, lying or giving his own false name. He admitted, or he does acknowledge his case in Columbia, and it doesn't appear he's not appearing. If released, he will be able to, he says, to reside with a friend who will be able to bring him back to court, and he has every intention of showing up at court. He is not trying to leave. He has long-standing ties to the community, so he's asked the court to consider much lower cash than the state is asking for.
Right. And any response from the state?
No, the state believes that the state believes that the amount requested is appropriate for the reasons previously given.
Right. I agree with the state, and I think their recommendation is a little bit on the low end. Nonetheless, I'll order $1,000 cash, condition that you not operate a motor vehicle, that you not use or possess any alcohol, that you not use or possess any controlled substances or drug paraphernalia without a valid prescription. I'm going to order that if you're not to be released until you've been connected with pretrial services, okay? So before you can be released, you'll have to have pretrial services come down and hook you up with any equipment, give you any information you'll need before you're able to be released from jail, okay?
So he does not want to waive then his time limits.
We'll keep the time limits in place then, and we are adjourned. Thank you, sir.
Brady is next. Terry Brady is the forfeiture.
Yep, we're gonna blow this. Jesus.
We have just 1 second before we get the next one.
Yes.
Thank you.
I think I'll say drugs, yeah. Great.
Drive safe.
Okay, good.
Good enough. There we go. Then we go right to the podium here, or yeah. Yeah.
This is Dane County versus Terry Brady, 25 FO 2511. Can I have appearances, please?
State appears by ADA Lillian Nelson. Mr. Brady appears in person in custody without counsel.
And you're Mr. Brady? Good afternoon. The state has decided to charge your case as an ordinance violation instead of as a criminal violation. Specifically, they've charged you with county possession of drug paraphernalia. I expect there will be an offer to resolve your case today. What that means is, whether you decide to resolve today or not, you'll be unconditionally released from custody for this case. However, if you have other cases, they could affect your release. And is there an offer to resolve?
Yes, it's court costs only.
Okay. So you have an absolute right to plead not guilty, and we can set this case for further proceedings. Like I said, you'd still be released. Otherwise, you can enter a no contest or guilty plea to take care of this case today. You'd be fined $114.50, and payment of that amount can be arranged through the clerk of courts. You'd have 60 days to pay, or you could reach out to the clerk of courts to try to set up a payment plan. Would you like to resolve today?
Yes, no, not guilty.
Okay, then I'll accept your not guilty plea, and I'll advise you that this trial will be to a judge unless the court receives within 10 days of today's hearing written notice of a request for a jury trial and a $36 non-refundable fee. That's to a 6-person jury. There's no right to an attorney in a case like this, but you can hire an attorney at cost to yourself if you'd like. And assuming nothing new comes in, I'm guessing the state will keep this offer open until the pretrial conference, okay? We're adjourned. Thank you. I believe that's all for today.
Yeah.
Oh, there's more?
No.
No, have a good holiday.
To you, April.
Bye, Kathy. I don't know if I'll see you tomorrow, but I'm not gonna be here next week, so. No, if I don't see you tomorrow, have a good holiday. All right. I don't think I'll see any of you before next week. So I never see, I know I'm